Okay, it's 12:30, so we're going to get started. This is week 5 of Bressler's webinar series. This week's CLE, we're talking on creditors' rights, workouts, and bankruptcy, how to navigate potential disruption due to COVID-19. Obviously, a very timely topic. As we were preparing for this CLE, I started looking at some of the recent numbers coming out from Forbes in terms of the unemployment numbers, which obviously are directly tied to the current state of the business world. So we thought that this would be a timely topic to talk on this week. And so with that being said, let's talk a little bit about our overview of where we're going to go for today's CLE. So I'm going to first introduce some of the concepts and our panelists. And then from there, we're going to have Luis Mendez speak on judgment collection, how to actually get that judgment in place. And then we're going to transition over to Evan Yablonsky, who's going to talk about some successor liability issues and piercing the corporate veil. From there, we're going to move on to Nick Comiati and David Pincus, who are going to talk a little bit on essentially settlement and figuring out bankruptcy issues. So before we go there, I guess I'll briefly introduce myself. My name is Lauren Valdivia. I'm a principal with Bressler's Fort Lauderdale office now. I relocated to Fort Lauderdale recently, although I still continue to litigate and practice in New York and New Jersey. On our panel today, we have Luis Mendez, who's an associate in Bressler's Alabama office. Luis has experience in a broad range of litigation matters, including securities arbitration, class action matters, contestable life insurance claims, and collection matters. Evan Yablonsky is a principal based out of our New Jersey and New York offices. Evan is a distinguished litigator. He's tried many cases, many jury trials, over 15. He represents clients in state and federal courts and arbitration tribunals throughout the country in complex litigation. We also have Nick Comiati, who's a principal based out of our Bressler's Florham Park in New Jersey and New York offices. Nick represents financial institutions in complex matters in state and federal court. He also practices heavily in the securities and litigation area. And he also serves as essentially outside general counsel for various clients, just based on his, vast experience in litigation and securities matters. And lastly, David Pincus, he's been an active litigator for 3 decades in New York and New Jersey. He handles complex litigation, including general commercial, bankruptcy, matrimonial, regulatory issues. So obviously, David has a lot of good experience for us. So we're going to start today by talking a little bit about the judgment collection process. Essentially, what is the process for obtaining a judgment? So Luis, can you just walk us through a few practice pointers for how you actually obtain that judgment?
Hi, Lauren, and thanks for that introduction. As Lauren said, my name is Luis Mendez. I'm an associate in Bressler's Birmingham, Alabama office. I wanted to go through some general practice points today that can be helpful and applicable to any judgment creditor in the process of collecting on a judgment. And so the first practice point that I wanted to emphasize to people and to judgment creditors is to follow the rules. This is a highly technical area of the law. Rules vary greatly from state to state and often require strict compliance with rules and statutory provisions to ensure that a judgment creditor is not getting tripped up along in the process of its judgment collection. Some basic issues that you're likely to encounter in each state as a judgment creditor are automatic stays on collection, statutes of limitations as far as how long you have to collect on the judgment, statutory provisions for notice to the judgment debtor and to any garnishees, and also procedures for recording the judgment. And one point that I want to focus on is the automatic stays on collection. So this is a period following the entry of the judgment, typically during which a judgment creditor is actually prohibited from taking any efforts toward collecting on the judgment. What's important here is to know that if you're a judgment creditor, there's likely an automatic stay that's going to apply to you, but it's equally important to check in each individual jurisdiction to determine how long that stay is going to be. For example, in federal court and also in here, Alabama, there's the automatic stay is 30 days from entry of the judgment. But even here, that rule in federal court was amended in 2018. So as I was doing my research, going through items online to research for this presentation, There were plenty of articles stating basically that the federal court stay was 14 days, got back to the rule, got back to the 2018 amendment, realized it was 30 days. So it just really emphasizes the point that you need to not only follow the rules, but be aware of the rules and stay current on them because they do change, and you want to have the most up-to-date information. In New Jersey and New York, the rules give the trial courts discretion on whether to enter a stay pending appeal. It often requires a motion for stay pending appeal, and the courts have different standards by which they determine whether to enter a stay. In Florida, again, emphasizing not a real difference, but a subtle one, the court also has discretion to enter a stay, but that stay is automatic if the judgment debtor enters a bond. So basically, you're likely to be subject to a stay. The contours of that stay can differ by jurisdiction, but regardless, while you are subject to a stay, there are some concrete steps you can take toward collecting on your judgment in the interim. And one of those, and it leads me to my second practice point, is to get in line and record your judgment. Recording the judgment is important because it creates a lien on the judgment debtor's property, and it gives you, as the judgment creditor, priority on the judgment debtor's assets before later to come creditors. And again, and you'll probably hear me say this a bunch of times during my presentation, but the rules on recording vary from state to state. Alabama, Florida, and New York require you to record the judgment in every county where the judgment debtor holds property, and will only create a lien on the judgment debtor's property in that county. New Jersey, by contrast, actually has a mechanism by which you can create a statewide lien and create a lien on any property held by the judgment debtor within the state. So really, the first couple of points are that there are rules and you need to follow them. I think the second, my third practice point actually, is that while there are a lot of rules and they can kind of constrict a judgment creditor in the collections process, the rules also do provide for a measure of flexibility and give a judgment creditor flexibility on how they want to collect on their judgment. I think this flexibility is especially important now where there is a lot of uncertainty surrounding the coronavirus and however we may ultimately emerge from the various public health measures that are currently being implemented. One example of a rule that can provide flexibility and what I want to focus on is the statute of limitations. Statute of limitations with collecting on a judgment are generally long. Most states, it's 10 years or at least 10 years. There are provisions by which you can renew a judgment and get an additional 10 years. Some states give you 20 years off the bat, but either way, it's an extended time period. And while there is understandably some urgency in collecting on a judgment, the point with the statute of limitations is that it gives you the flexibility if you do need it. Another measure that can provide a lot of flexibility is that there's a broad variety of mechanisms by which to collect against assets. So there are wage garnishments, which again, state to state varies on what percentage of wages you can garnish. Bank or securities account garnishments, which allow you to garnish any cash and can also require liquidation of securities to satisfy the judgment. Here, something to keep in mind is that retirement accounts such as IRAs and 401ks are typically exempted from garnishment. So if that's the only securities account you can locate for your judgment debtor, it's generally going to be exempted. It's going to be hard to collect against those assets. One other mechanism you can use is executing against real property. There are a lot of technicalities and formalities with executing against property, but if you do go down that road and you are in a position where you're about to execute against property, I think it can create a great incentive for the judgment debtor to step in and try to satisfy the judgment before you're selling their vacation home. I think, Lauren, as we were talking about this yesterday and running through our presentation, I think you actually had some similar experience to that.
Yeah, so I was going to say, anecdotally, I actually was successful in having a motion to force a sale granted by a judge. And here it was very interesting. It was a New Jersey case. So the first rule is really that you have to know that you have to show you've done your due diligence to execute first out of personal property. And to the extent that there is no personal property, there's nothing in any accounts, there's no potential wages to garnish against, only then in New Jersey can you then go to the execution against real property. In one case, anecdotally, we were successful in executing against real property because there the debtor actually had no personal property, a little bit of money in, this bank account or that bank account. We were not really able to determine whether she had anything else other than that property. She was very evasive in some of the collection mechanisms for discovery after the fact, which I know Lewis is going to speak on. And so we moved to compel the sale of a second property. And that motion to compel the sale was actually granted. It was a second property. It was not the homestead property. But because that motion was granted, very quickly that debtor came up with six figures to pay the prior debt. So Lewis makes a really good point that, even though it's very rare to get a motion to compel sale granted, if it is in fact granted, or even if the motion is prepared and filed, that may provide that good incentive for a debtor to suddenly come up with the money that they a week or two prior did not have. So I guess speaking on that point then, Lewis, what are the ways that you can try to locate information or locate assets? How do you do that?
And thanks, Lauren, for that intro into my fourth practice point. We've talked about rules. We've talked about, how you can collect, how do you find assets. And my fourth practice point there is to do your homework, but to do it efficiently. There are a number of ways to find assets, both through court mechanisms and outside of court mechanisms. And I think a judgment creditor should avail themselves of all of these mechanisms, and also should keep in mind at all times that you're trying to work toward collecting on a judgment in the most efficient manner possible, because all of the time and resources that you invest into collecting on the judgment are ultimately in one way or another eating away at your recovery on the judgment. So the first place I like to look for assets and use is asset searches through our typical legal research and legal entities like Lexis or Westlaw. It allows you to identify real and personal property that can be executed against, again, banks or bank accounts or security accounts that you can garnish, and also any employers to which you can direct a wage garnishment. Some more sources of information outside of the court context are county tax appraiser websites. Will have information on any real property holdings. State Secretary of State websites, to the extent the judgment debtor owns an interest in any LLC or company in that state, you should be able to find information against that. And also Google and social media searches. It may just be the millennial in me, but I love checking Facebook and Instagram almost as much as people love posting pictures of their second homes and new cars. So that can be a really good source of information if you have a judgment debtor that is being otherwise evasive. Within the court framework, which I think is covered in the next slide, there are also a number of procedures that can be used to obtain information. All states and federal court have provisions for post-judgment discovery. And in some senses, this post-judgment discovery is actually broader than you would get in a typical civil case. It allows you to obtain discovery, quote, in aid of execution, and also makes all the typical forms of discovery like depositions, requests for production, and interrogatories not only applicable to the judgment debtor themselves, but applicable to any person. So here, again, I like to keep in mind and toward doing my work efficiently is to avoid throwing good money after bad. I think the best thing you can do is to try to maximize the amount of information with a minimal investment of time and resources. Some good options here: interrogatories to the judgment debtor. Again, this can vary in effectiveness based on how cooperative the judgment debtor is being, but to the extent that you do have a cooperative debtor, these require a sworn response. They're required within a certain amount of time. And if you don't get a response, there also are enforcement mechanisms like motions to compel, motions for sanctions, that you can drag the judgment debtor back before sometimes the same judge that they were in front of in the underlying action. Other discovery methods that can be used are document requests and subpoenas to accountants, banks, investment firms, and employers. With accountants, there can be an accountant privilege. The contours of it really vary by state and just how strictly it's enforced in each state. But regardless of how it's enforced, you should be able to obtain discovery of any filed tax returns, which can be a great source of information on assets. One final point I want to make, and it unfortunately didn't make it into my slides, but something to keep in mind: if you're collecting on a judgment, especially if you're an attorney that practices frequently in this area, is the Fair Debt Collection Practices Act, the FDCPA. Under the FDCPA, an attorney can actually qualify as a debt collector. And if you qualify as a debt collector, if you practice enough in this area to qualify as a debt collector, there are a host of rules and regulations that you need to abide by and should keep abreast of. And with that, Lauren, thanks for giving me the time to speak.
Yeah, of course. I mean, I don't feel as cool as you because I've never managed to reference Instagram during a CLE. So new goal moving forward. All right. So you have your judgment. You generally know how to first locate assets. Sort of what is the next step in terms of actually getting to those assets? So Evan, I know that you had some thoughts on how to figure out how to follow the money.
I do, Lauren, and thank you. And thanks, Lewis, because not only am I not cool enough to mention Instagram, I don't even have an Instagram account. So I'm even further behind everybody else. Lauren, I thought your and Lewis's example was a really good one, and now one we can start from. You've got a judgment. This individual has a second home. But what do we do when that home isn't in the state where you've got your judgment? When we're talking about states to state, it's relatively easy. If you've got a judgment against an individual in New York, they've got a home at the Jersey Shore, no problem. If you've got a judgment against a company in New York, they've got assets in Pennsylvania, right there. They've got some factories out in PA. That's not a problem. Just about every state has adopted the Uniform Enforcement of Foreign Judgments Acts. And what that does is it allows one state to enforce a valid and final judgment in another state. Pretty much all you need is a final judgment. You take that judgment, you get an exemplified copy of the judgment from the state where you received it, and that's just a fancy way of saying it's got to have a couple extra signatures on it, and you enter it in the new state. So once that's done, all those steps Lewis talked to us about, you can now avail yourself of those actions, those wage garnishments, those executions. As long as you're following state procedure where the asset is located and you've properly domesticated under the UEFJA, you're all set to go. Similarly, with a federal court judgment, 28 USC 1963 essentially allows you to do the exact same thing. You take it from one federal court to the next. So that's our simple example. It gets a little more complicated when you start talking about a judgment that you've got here in New York City, but all the assets are in London, Paris, Tokyo, Dubai. Pick a country. When you start getting into serious asset execution and some bad actors that are trying to hide their money, their assets, the British Virgin Islands, the Cayman Islands, Bermuda, and Barbados. So that becomes a little more difficult. Now, it's not impossible by any means, though. The United States doesn't have any bilateral or multilateral treaties that allow the automatic enforcement of these judgments, but just about every jurisdiction has a procedure for enforcing a foreign judgment. And what you typically find is there are 4 challenges to enforcing a foreign judgment. Challenges based on jurisdiction, notification, fraud, and public policy. And we'll kind of walk through those. So the first issue is jurisdiction. Did the U.S. court, or the court that entered the judgment, actually have jurisdiction? If you can remember long ago in the United States, you actually had to get served in the state or appear there for jurisdiction to be valid. That's obviously changed over the years. Now we've got our minimum context test, as long as it doesn't offend the traditional notions of fair play and substantial justice. But that's here in the United States. that doesn't mean that that is the rule for jurisdiction in London, in Toronto, pick your jurisdiction. Some countries apply a real and substantial connections test. Others have their own standards. So you want to make sure that you're doing everything you can to lock down that personal jurisdiction, make it as clean as possible. And if you know at the beginning that you're going to be looking for assets in other countries, right? If I know I'm getting a judgment here in the United States, but they have oil contracts in the UAE, what does the UAE require for personal jurisdiction? You always want to do your homework up front to make your life easier in the future. Second challenge that there is was the defendant properly notified? This is usually a pretty simple one. Was there service of the defendant, who then becomes the judgment creditor? Did they participate or have the opportunity and notification to participate in the underlying proceeding? Again, that one's a pretty simple one. The third challenge that you often find is, were the proceedings fraudulent? A judgment's not going to be enforced if it was obtained by fraud. U.S. judgment, not typically a problem, right? We've got whole thick books filled with rules and processes and procedures to make sure that our judgments are not obtained by fraud. What if you're taking a judgment from a foreign country and seeking to domesticate it in another country? Well, you want to make sure that those fraud allegations can't be made. And then the final challenge that we'll see is, was the judgment contrary to public policy of the foreign nation where you're trying to bring this judgment? And this is essentially, Lauren, nothing more than a jurisdictional morality test. Was there something about this judgment that offends the morality of the country where you're seeking to execute? Some countries don't allow for taxes, fines, penalties, things of that nature to be enforced. One example I can give you is, we had a judgment here in the United States. We had post-judgment discovery exactly along the lines that Lewis told us about, and the judgment debtor refused to comply. They would not answer our discovery, would not turn over our documents, and it got to the point, after motions for compel, motions to contempt, we convinced the United States District Court judge to issue an arrest warrant for this individual. He showed up in the United States, he was getting arrested. Problem was, he didn't live in the United States. He lived abroad. And in that country, for a civil action, you couldn't have an arrest warrant issued. So that was an example where the morality of that jurisdiction did not allow for the enforcement of a U.S. order. So those are the types of things you want to pay attention to. And the other thing you want to keep in mind when you're deciding where to go is, just because there's assets in multiple jurisdictions, which one do you want to go to? Lewis mentioned before the accountant privilege. Well, if I'm at the early stages of my judgment enforcement, my post-judgment discovery, those accountant records can be really, really important, right? Third-party records are so important in finding assets. So if I know that I've got assets in 2 states and I'm debating where I want to start taking my next step, well, if I know one of those jurisdictions does not have an accountant privilege, in other words, I can get all of the work papers, all of the underlying documents in addition to just the tax returns, that's a good place to go. If I want to go after a member's interest in a limited liability corporation or company, some jurisdictions will allow me to do that. Other jurisdictions say, unless that LLC, there's a sale, you can't garnish that membership's interest. Similarly, there's homestead exemptions. Certain jurisdictions have incredibly strong homestead protections. You know, your home is your castle. Others just cap the value of the home and then you can go after it. Joint tenancy and property owned by a husband and a wife. Similar, some states will make you have a judgment against both. Others, you only need it against one and they'll allow for certain execution. So I think you need to pay attention to the rules in each jurisdiction when you're actually picking those jurisdictions.
Yeah, and let me just interrupt you for a second, Evan. So I know David Pickus is on the line here with us today as a panelist today, although it looks like he's not showing up by video. David, if you're there, is there anything specific to New York that you can kind of share as it relates to, you know, picking a jurisdiction? Is there anything special that makes New York, an appeasing jurisdiction? an appealing jurisdiction, excuse me. David, are you there with us still? All right, so let's move on then. I guess let me ask you then, Nick. I know that you had some
man, I got to talk about New York? I thought I was talking about Florida.
No,
Can you hear me?
I won't hang you up for New York.
Oh, there's David. David just
There's David. David, is there
I'm
anything
having
particularly appealing about New York that that perhaps somebody would want to move and try to take enforcement action in New York?
New York can be a very advantageous place to enforce a judgment because attorneys have a lot of latitude without needing the sheriff or a court order. And specifically, if you've got a money judgment, either out of New York or that's been domesticated in New York, an attorney can issue a restraining notice to a bank or to anyone else who owes the judgment debtor money, and that restrains the account or the asset, whatever the case may be, and that will buy you some time to be able to bring a turnover proceeding in the court or use other methods, sending the sheriff out to actually levy on the bank account. So that's a very flexible feature that New York offers. On the other side of the coin, one has to be careful because New York has an oddity called the separate entity rule. And under New York's separate entity rule, which you'll not find in a statute anywhere, but it was made by our highest court, the Court of Appeals, each branch of a bank is treated as a separate entity for enforcement purposes. And I'm not talking about within the state, but I'm talking about outside of the state. So that if someone has an account in Bank of China in Shanghai, but they have a branch in New York that doesn't hold the depositor's funds, you can't attach the funds simply by serving garnishment papers or restraining notices in New York. It's an odd rule, but it's been in effect for a long time, and it's designed because they want to keep New York as a center of business activity and not make people fear that their assets are going to be garnished based on something that happened overseas or in another state for that matter.
Thanks, David. That's very helpful. And then I guess, Evan, you briefly referenced fraudulent transfers. What are the nuances involved when it comes to fraudulent transfers?
Sure. Thanks, Lauren. And I think that's a great segue because not only do we have judgment debtors who have assets in other states, but we're not always dealing with the most upstanding people. And so oftentimes what we'll see is a transfer of assets, right? Whether it's a sale, a loan, whatever, where a transfer by a debtor goes to another individual, another entity, and the key for it to be fraudulent and therefore subject to avoidance, in other words, for us to be able to pull it back, is if it's made by the debtor with the intent to hinder, delay, or defraud a creditor. And those are pretty hard things to prove, as you can imagine, right? We're talking about how do you show that someone did it with the intent? And we have what's called badges of fraud. So you want to look at things like, was it a transfer to an insider? Did the individual transfer the asset to their sister, their mother, their brother, their husband, their cousin, their best friend? Who did it go to? You and Lewis talked about, second homes before. If I transfer my, a ski home to my cousin on paper, but every weekend I'm still the same person that's going there, I'm using it in the exact same way. In other words, I've retained possession of the asset. Well, that can be a fraudulent transfer. You want to look at steps taken to conceal that transfer. And timing is really important as well. You want to know, was it during the litigation, was it after litigation, or did they at least have notice of the pending litigation? You want to be able to tie that transfer to that they knew this was coming and did it for the intent to avoid. You also want to look
Let me interrupt you for a second, Evan. So what happens in a jurisdiction that has really strong joint tenancy protections. I guess, Nick, let me throw that to you. What happens when we're in a jurisdiction that really respects the nature of joint tenancy? What happens in the fraudulent transfer situation there?
Well, it can be very difficult to get into any kind of joint tenancy. For example, down in Florida, very strong homestead, very strong joint tenancy rules. In New Jersey, if you have an account with $1 million that you own jointly with your wife, and there's a $500,000 judgment against the debtor, you'd be able to collect against that half. There'd be half that would be protected. In a state like Florida, the entire asset would be protected. So you really have to dig into these fraudulent conveyances to see what's actually created, or a tenancy by the entirety was created. So if you have a scenario where we once did, where we had somebody who was married, divorced, and then he signed his divorce papers about 15 minutes before he signed his wedding certificate, his marriage certificate, you can seek to undo that transfer based on the fact that he was trying to maintain his judgment-proof status ostensibly the entire time. He never had a dollar in any account that was owned by himself. Everything was always joint. Stole the divorce, so he had a new marriage that he could take advantage of and shield those assets. So it's really important to go to Evan's point on timing, to investigate when those tenancies were created, when those when everything was created, in order to utilize the tools of undoing a shield through to the fraudulent transfer.
So Nick, you broke up once or twice. Nick, you broke up once or twice there.
Yeah.
So what I'm hearing you to say is essentially that there are situations where there's joint tenancy where we really need to dig deep to look at the timing of transfers and sort of the underlying facts as it relates to transfers. And I think I'll throw it back to Evan here. Evan, it sounds like
real quick, we need to give our first code, which is Creditor for the CLE credits.
Got it. Perfect.
And don't take anything at its face value, I guess I would say as well. If you're looking at these things, I'm married, it's a joint tenant. Well, dig in. And we had to go through the history of when and the timing of when everything had occurred in order to get to the bottom and wind up getting a much more advantageous result as a result of the work.
Thanks, Nick. Thanks for that real life example. And then I guess, Evan, were there any other sort of hallmarks when it relates to fraudulent transfers that we should really be looking out for?
I think the other thing you really want to pay attention to, and Nick's absolutely right, you've got to do your homework, you've got to drill down into the details, but is fair market value. The simple example is I sell, a brand new BMW to you for $5,000 when it's worth $50,000. That's obviously not fair market value, and that's an easy one to see. But when you start talking about the sale of businesses, client lists, things of that nature, you've really got to drill down and make sure that you understand how the valuations are happening, how they were created, and what tricks are being used in terms of how things are being marked as assets on their financial records. Are they being marked as non-collectible, unreceivable, even though it really just got transferred away? And I think where you'll see a lot of that, Lauren, is when you start talking about successor liability. You'll have company ABC who you get a judgment against, and suddenly that company's got no money, no assets, and it's closed down, but the principals have opened up, BCD Corp, and it has the exact same business. Well, is that a successor liability? Because the general rule is that the obligations and liabilities of a company are not imposed on the successor. But that's not always the case. You want to look at things like, was there an assumption of the obligation? Was there what we call a de facto merger or a mere continuation of the predecessor? Or was there some fraud that caused this to happen? And again, to Nick's point, I think, is you really have to drill down. You have to get into the documents because you want to look at what's happening. Do you have the same shareholders and board members from company 1 to company 2? Is it in the same office location? Are they literally sitting on the same office furniture, using the same computers? Was there a transfer of actual assets? Take a look at the client list. Can you match up that those are the same exact clients? Maybe they have different names, maybe they're structured a little differently, but when you kind of peel back the veil, can you actually see what's happening there? And timing. Again, timing always matters. Did these businesses overlap at all? If they did, can you see one client list going down as the other goes up? You want to take a look at exactly the timing and mechanism at which they're doing this. And then I think that probably brings us to one of the last kind of things that you'll see in this world is that piercing the corporate veil. Was the individual, the corporate owners, actually using these companies as, to put it in colloquial terms, as their piggy bank? Were they actually using this company for the corporate gains, or was it a mere instrumentality, an alter ego of the defendant, and that they engaged in improper conduct in the formation or use of the corporation? So again, you're looking at things like domination and control of the entity. Were there individuals who so controlled that entity that it was truly theirs? And you can't just look at what's on paper. You have got to go talk to the employees. You've got to take depositions. You've got to talk to the people. Just because I say that I'm not the CEO and I promoted, my assistant to the CEO, well, did that assistant get change in responsibilities? Did they get greater pay? Am I still calling all the shots and making all the decisions? How am I using those corporate funds? Am I actually using them for corporate means, or did my family vacation to Italy suddenly end up on the corporate Amex along with my business partner who happens to be my best friend, and we called it a work meeting, on the coast? Is the business adequately capitalized, and were there arm's length transactions? Loans is a huge thing you want to look at. Any loans that are coming out of that company that is now dead and aren't being paid back, how were they used, and what was their forgiveness? One example we saw was an individual who gave a horrible loan to a friend, and then suddenly that loan ends up on the corporate books. There's a repayment of a month or two's interest, and then that loan is written off as uncollectible. Well, that was clearly a transfer amongst insiders. It's a fraudulent transfer, but it also can be grounds for piercing the corporate veil. Another example is management fees. You want to look at what other fees are being paid by this business. If I own a business and I'm paying my 5 other entities to do all the management of it, that could be legitimate, but it could also be a really easy way for me to funnel money out of my company because I know this judgment is coming down from a different entity. So I think those are really the things you want to look at. And with that, I'll turn it back over to you, Lauren. Thanks.
Well, Evan, actually, I know we're talking more on the creditor side, but
Sure.
Another thing, if you are advising or if you are working with an entity that does issue loans, you need to be cognizant of potential piercing claims as well. And while most states are pretty friendly, there are some states that have a more broad expansion of the piercing the corporate veil test, so it's not alter ego, single business enterprise. Those states, you want to make sure that you are using a choice of law provision that avoids. I know Louisiana is one of them where it's a little bit easier to pierce the corporate veil. So if you kind of loan to another entity, if that entity is in distress, you have to really be careful that you are making sure that anything that could possibly be construed as controlling that company is avoided.
Yeah, I think that's a great point, Nick. And similarly, I think you always want to be careful. If you know there's a company that's going under and having a fire sale, you need to be careful in paying attention to what you're buying and what kind of business deals you're entering into with them, because you don't want to be on the other end of one of these lawsuits.
Exactly, and that's, I think, something that what we start to see companies come into distress, taking too big of a hold on the wheel could be problematic.
All right, thanks, Evan. So that was great, talking about tracking down those assets, essentially. So let's transition, I guess, onto the next topic, which is essentially negotiations with debtors and potential settlements. Because once you have the judgments, once you've done your due diligence to locate the assets, and even perhaps you've managed to identify some assets, or maybe you're faced with some questions about some of the issues that Evan raised in terms of whether or not you want to make a motion or bring an action to perhaps pierce the corporate veil, there's always going to be settlement talks. Well, maybe not always, but there's usually going to be settlement talks at some point. And even before COVID became an issue, we know that, you know, generally when you have a judgment, there might always be issues in terms of collectability. Now, with COVID being sort of the new world we live in, we know collectability might even become a bigger issue. You know, having money in your hands now for a judgment obviously is better than spending years trying to track down the judgment that, you know, perhaps you'll never actually be able to collect on. So, Nick, I know that you had some thoughts on negotiations with debtors and settlements, and I know that Dave is going to join in before he talks about bankruptcy to help talk through some of these topics on settlement.
Yeah, and the reality is the world that we're living in now is going to result in some default on some obligations. It will be prudent a lot of times to try to work something out with a debtor. And the key, if you are representing a creditor, is to make sure that you are not compromising any potential worst case scenario happens that the debtor has to declare bankruptcy. So if you're making any concessions regarding the amount that is owed, you want to make sure that your client or your company is protected as much as possible in the event that there is some kind of bankruptcy down the road. There's the preference claims. Once an entity is into bankruptcy, are available to a trustee, where if you make any kind of settlement involving a payment, it could be voidable if the defendant files bankruptcy within 90 days after the payment. So you want to make sure that if you are entering into an agreement, you do your best to protect that total amount that's owed. You can put in different provisions there. If there's any kind of exchange of new value, you have a defense to a preference claim, called the contemporaneous exchange of new value. If there's some kind of additional consideration that you can include in any kind of agreement, that would be preferable. A lot of times you can't include something like that, so you know, it's difficult to enhance or it's a value of not having that litigation. You can make the argument that we were in a litigation and the attorney's fees that would have been expended were a benefit, but that is a risky proposition in bankruptcy court. You're never going to be able to fully eliminate any potential exposure to a preference claim. However, you can minimize it. You can provide in your settlement agreements that the original claim was preserved. You can put in language into any kind of agreement that if you can't obtain the full amount of the settlement for any reason, that the full amount of the claim is owed. Obviously, in bankruptcy, usually you're going to be getting pennies on the dollar, some kind of form. So having the largest amount of a claim is most preferable. And you want to make sure that your company or your client has the ability to, in the case that the debtor can't make the payment ultimately, that your client or your entity has the ability to put in for the full amount that was in dispute originally. Another mechanism is to delay the release until the 90 days, essentially the preference look back has expired. if there is some kind of preference that claim still remains valid. But again, there's no guarantee that it will survive any kind of preference challenge. So when you're working through problems with a debtor, you want to make sure that you go into it, especially in times like this, eyes wide open, that there is a possibility that that entity may have to file bankruptcy. And in that case, depending on the type of bankruptcy, there could be potential actions against you where or you have simply worked with that company and tried to be the good guy. You run the risk of having the entire payment pulled back. So it's something to enter into those negotiations always with the worst case scenario in mind and make sure that you are doing everything to protect your entire potential claim. Oh, you're on mute, Lauren. Oh, now
So you broke up a little.
I tried to help you.
No worries. So you broke up there a little bit at one point, but I understand you to be saying that essentially you could be doing everything right, but you still need to have the mindset in place that perhaps there might be a bankruptcy later down the line that could void all of the work that you've done, correct?
Yes, that's absolutely the case. And you don't want to compromise a potential claim down the road because you were trying to be, work with the company. You're trying to be the nice person. You're trying to help them through. And then down the road, that all goes out the window and you run the risk of having to enter into a litigation where you are, going to be starting with a lower ceiling. You want to make sure your ceiling is as high as possible in a scenario of a bankruptcy so that your claim is as large as it can be and you have the greatest likelihood of getting a larger number to collect upon.
That makes sense. So the general takeaway is protect the entire amount. But let's say that you do in fact move into the bankruptcy realm. I know Dave has a lot of experience in this area. So Dave, did you want to speak briefly about the different types of bankruptcies involved?
Sure. And I'll just, before we leave the other topics, add two of the best ways to secure yourself against a preference claim. One of them is to get a security interest, to get some collateral and make sure it's properly perfected before you hit the 90-day period. And the second is to get some kind of a guarantee of whatever your settlement is from a non-debtor entity, either the principal of the debtor or an affiliated company that's not in bankruptcy.
Great points, David. And you just have to work with and cut the best deal, because in this environment, if you're looking for cash flow, you're going to have to do the dance about what you can get from the debtor, what they're willing to agree to, because a lot of times those principals are not going to be too willing to give you a guarantee.
Yeah, and just as a practice point, I generally advise clients, don't refuse the money because you're afraid of a preference. You're always better off holding the money because it gives you an opportunity then to cut a deal with the trustee down the line. Maybe you don't have to give all of it back. Right. So that's just a practice point. Lauren, getting back to your question, I really don't, and all of us on the line don't have time to go through the entire framework of the bankruptcy code. Basically, there are three forms of bankruptcy protection. One is a Chapter 11, which is the route that most commercial entities take, and that is a reorganization. It gives the debtor an opportunity to come up with a plan to satisfy creditors and to resume business on a different scale, or to sell the business or sell certain assets. Chapter 7 is akin to a liquidation. That basically means that a trustee is appointed to liquidate the remaining assets, if any, of the debtor for the benefit of creditors. Many Chapter 7s are no asset cases. Chapter 13 is used basically by individuals to restructure their debt so you can elongate credit card payments, affect other debts to pay them out more over time, to cut some deals with creditors. The one thing I wanted to mention, because I think it's going to be particularly appropriate in the COVID-19 environment, is something that by sheer coincidence was enacted by Congress last year, called Chapter 5 Small Business Bankruptcy. This was designed because a lot of small business owners really didn't have the ability to reorganize and pay for a reorganization in a Chapter 11, and at the same time, they didn't want to go out of business in a Chapter 7 and strand their creditors and leave themselves unable to sustain the business. So Chapter 5 is a streamlined procedure that allows certain small businesses, and I'm not going to get into all of the criteria now, we don't have time, but basically for small businesses to have an opportunity to reorganize and for the owners of the small business to be able to retain their ownership interests. In some ways, it's a hybrid between a 7 and 11 because a trustee is appointed in a Chapter 5 proceeding. And the idea is that the small business trustees will help the owners to get the business back on its feet. The idea here is, again, to let the prior owners have some continued interest in the business without having to contribute new value to it, which is usually the standard for an equity holder to maintain some interest in a bankrupt business, and also to make it easier for these small businesses to go into bankruptcy, to be able to come up with plans and to be able to keep the business alive. My suspicion of what's going to happen as a result of COVID-19 is that we will see a lot of larger companies survive, reorganize, avoid bankruptcy entirely, but the real victims of this COVID-19 are going to be small businesses, restaurants, small service businesses, nail salons, hair salons, and there are a lot of them. And Chapter 5 may give the principals and the owners of these businesses a second life. Otherwise, I think that a lot of creditors are going to find that it's not worth their time and money to chase some of these debtors through a bankruptcy proceeding, especially through a Chapter 7, simply because they're not going to have assets to pay creditors.
Absolutely.
That makes sense. So it sounds like you think Chapter 5 will be the go-to for some of these small businesses in the upcoming year, David.
Yeah, that's right. And, if you happen to be out there and you run into your barber or your favorite restaurant owner who is asking you at a cocktail party, what do I do now? What can I do? Suggest a Chapter 5 bankruptcy.
Awesome. Okay, let's talk a little bit more in terms of the automatic stay provisions generally in bankruptcy.
Well,
what are the effects of the stay?
Okay, well, this is important if you haven't dealt with bankrupt people or entities before. Upon the filing of a voluntary bankruptcy petition, whether it be under Chapter 7, Chapter 11, or even a 13 or a 5 in most cases, an automatic stay applies. That means that you cannot continue litigation against the debtor, you can't start litigation against the debtor, you can't take measures to collect your debt. The whole idea behind the automatic stay is twofold. One, it enables all creditors, at least unsecured creditors, to be treated equally so that nobody gets an advantage by continuing their litigation and bringing it to fruition. And the second, of course, is to allow the debtor an opportunity to reorganize and take a deep breath in order to try to raise money, keep the business going so that it can protect the creditors. The other thing to know about the automatic stay, however, is that it doesn't just relate to collection measures, lawsuits, etc., but any attempt to exercise control over the property of a debtor can be a violation of the automatic stay. So if you happen to be holding property of the debtor, but you don't have a perfected security interest, you can't take that property, sell it, and apply it towards your debt without a court order. There are a number of other things that one could do to exercise control over the property of the debtor that would be a violation of the automatic stay. So you have to be very careful about that. And the automatic stay is a very potent weapon. Someone can be held in contempt. Somebody can be held liable for sanctions for violating the automatic stay. And the other unfortunate component of the automatic stay is that some courts have held that even if you don't have knowledge of the bankruptcy, bringing a lawsuit or taking collection measures in violation of the stay can be actionable. Now, in most cases, if you're ignorant, if you were left off the schedules, if you didn't have notice, the bankruptcy courts will be pretty indulgent of you, and you'll get off with a slap on the wrist at most. But if you've got a debtor that's not in bankruptcy but is teetering on the brink, before you start a lawsuit, before you send collection letters, it wouldn't hurt, and in fact it would be advisable, to check PACER or any of the other public notice websites that are available to make sure that this company or individual is not in bankruptcy before you start taking action to enforce your debt.
Hey, David, it's Nick. We have a good amount of financial institution folks who are on. Can you, and I may have missed this, but can you briefly talk about if you freeze an account, would that be subject to an automatic stay?
Yeah, that becomes a subject of litigation very frequently. For example, if you have a restraining order out there with respect to an account, whether that restraining order continues. Now, usually the burden is on the judgment creditor who obtained the freeze on the account to lift it once or to get the court's permission to continue it once the bankruptcy petition is filed. If you are holding money in a frozen account and you get notice and you're a financial institution, the best thing to do is to get guidance from either the debtor's attorney or the trustee or from the court before you take any action. For example, the right of set-off. You might have a contractual right of set-off if you're a financial institution, if the depositor also happens to be a borrower. But before you exercise that, you should get court permission. The one thing that excuses you to some extent from the automatic stay, you still have to get court permission, is if you have a security interest. If you have a security interest, you should be able to obtain relief from the bankruptcy court so that you can go ahead and foreclose on your security interest, but you still need permission. And we have a saying among the bankruptcy bar, ask permission, not forgiveness. So it's best to be preemptive about these restraining notices and other things. And if the debtor contacts you and wants the freeze on an account released, either you need to do that or you need to get guidance from the bankruptcy court.
Absolutely.
Okay, that makes sense. Well, thanks, David. I know that we didn't get through all of the bankruptcy litigation materials that you wanted to speak on, but I'm sure anyone who has questions can reach out to you afterwards about anything related to bankruptcy litigation. By the same token, we didn't get any sort of questions and answers before this hour was up, so you guys can certainly reach out to any one of us about any of the topics that we discussed today, and we'd be happy to follow up on it. So with that said, thank you so much for joining us for week 5 of the webinar. I'm sure there will be another webinar next Wednesday, week 6, and we thank you for your time today.
And code 2 is debtor.
Thank you. That was creditor as code 1 and debtor as code 2. Thanks, guys. We appreciate it.
Right.
And it's in the notes as well. Thank you so much. Have a good one.